I'm a foster care supervisor at the Department of Health and Human Services, currently overseeing this case.
All right. And as to the documents identified by the court and admitted into the record, are you familiar with them?
Yes.
All right. Since we're here on disposition for Mr. Alan Stevens, can you tell us what plan has been created for purposes of reunification with his child, Felix Stevens?
So currently, Mr. Stevens's plan is pretty bare bones, due to some inability to assess certain dynamics, specifically his parenting skills as it would relate to Felix. Mr. Stevens has not participated in any parenting time or contact with Felix. Therefore, we're unable to properly assess the domain of parenting skills. He does have seem to have some strengths as noted throughout the PATP. He appears to be in a healthy relationship. He appears, by his own report, to have good social support system. He does communicate with the department. He has adequate housing, which he has allowed DHHS to visit for home visits recently. There's no apparent intellectual delays or resource barriers. He is employed and appears to have adequate income to meet his household needs. Um, no reported physical issues. So the only thing we were able to assess at this point with the information we had as a need would be child characteristics, so involving himself essentially in the care of Felix, so attending and participating in any of his medical or other therapies that are recommended for him so that he has an understanding of Felix's needs um, in terms of looking at reunification. Like I said, though, Mr. Stevens has not chosen to participate in any parenting time, so his stance to the department has consistently been that he does not believe he is Felix's biological father and that he's not wanting to participate in reunification services or parenting time until a DNA test can be completed. The department has reiterated that he is the legal father, and therefore the department does not offer DNA testing. So we're a little bit at a standstill when it comes to that issue.
Okay, so Mr. Stevens has not had any contact with the child the entire case?
Correct.
All right. And but you said he does communicate with the department regarding a plan for reunification.
He communicates with the department in terms of consistently expressing that he does not want to participate in parenting time or efforts for reunification without a DNA test having been completed establishing him as biological father. He seems to understand that he is the legal father. But like I said, is not interested in any parenting time thus far. Um, so there's not really any movement in terms of reunification planning at this point. Without parenting time, we're not able to assess if there's any barriers to his ability to parent Felix or meet his needs.
All right. The parent agency treatment plan indicates that he is able to read and communicate. This is dad.
As far as we're aware, there's no barriers in that area. He does
Okay.
text with Miss Lucy, the assigned worker.
All right. And then he does have pretty stable employment as a cook.
Yes, he reports consistent income.
All right. And then he has a place to live, an apartment.
He has allowed Miss Lucy to verify his housing. Yes.
Okay. So so we have a plan here. However, if I got this right, let me know that Mr. Stevens is not really given the department a lot of information to come up with a more detailed plan.
Correct. Without being able to establish a relationship, well, contact really, but furthermore, a relationship and the ability for Felix and Mr. Stevens to create a bond, we're not really able to move forward.
Okay, and you are asking the court to adopt there were four parent agency treatment plans, and you're asking the court to adopt those as the plan for reunification?
They're all pretty similar. I would rely on the most recent treatment plan period, which is 10/7/2025 to 12/30/2025. We will have an updated report again in, I think it's March. But the October to December 2025 report is the most recent. Like I said, it's pretty bare bones in terms of how to assist with reunification because of the lack of contact. I do anticipate that if contact can occur, that, between Mr. Stevens and Felix, then we would probably be updating this plan in future reports. So right now, the only need domain is child characteristics, essentially him being involved in Felix, his needs day to day, in order to understand how to parent him. And like I said, we can't assess beyond that, can't assess parenting skills one way or the other. It's marked in our system. It doesn't show on the report, but it's marked as unable to score due to lack of contact.
Okay, is parenting time offered between Mr. Stevens and his son?
Yeah, Miss Lucy consistently checks in with Mr. Stevens to see if, he's changed his mind at all, if he wants us to schedule anything. But he has consistently voiced that he is not interested in arranging any kind of contact at this time.
All right. Can you tell us the child is in placement with who?
Yes, he's placed with all of his siblings, and he's doing very well. He's placed in a relative placement.
All right. Are all of his needs being met there?
They are. Yep, he has consistent therapy as recommended by his medical team at DeVos. And he is behind on immunizations, but when DeVos recommends, he'll be getting updated on those.
Okay. And do we know, has Mr. Stevens, has he ever met Felix, his son?
Off the top of my head, I believe when he was very young, but it's been an extended period of time that he has not had contact.
Okay. And really, historically, based on the allegations in the petition and Mr. Stevens' plea, it was a lack of contact and not providing proper care and custody that brought us to this disposition today. Do you agree with that?
That's correct. From what Mr. Stevens has shared, it's consistently been the concern of whether or not he's the biological father that has prevented him from caring for Felix.
All right. Would you like to offer anything else this afternoon?
I don't think so.
All right. Thank you. Nothing further, Judge.
Mr. Brown,
No questions, Your Honor.
Ms. Hansel.
No questions.
All right, Mr. Delaney.
Just a brief follow-up on the parentage issue. And I think you testified to it, but it's in the petition that Mr. Stevens did sign an affidavit of parentage. Is that correct?
To my knowledge, he did, and to my knowledge, he is the legal father.
All right. And is that document in the possession of the department, or were you just advised of it, or do you know?
I don't recall offhand. I would have to do some digging in the file to verify.
All right. at your convenience, can you see if you could obtain that document and circulate that to council?
Well, I can certainly try. I would just note though, in prior court hearings that he was identified as the legal father. So I'm inclined to believe that that document was in fact signed and produced. I'm not sure if Miss Sullivan is the CPS worker would know offhand.
As to that affidavit, have you had an opportunity to speak with Mr. Stevens about that? Does he deny signing it? Or had you not spoken to him and maybe Miss Sullivan's the person to speak to?
I have not spoken with him directly about that. My understanding from Miss Lucy is that he does not deny signing it, that he acknowledges he signed it, but that he does not believe that he should make reunification efforts without a DNA test proving that he's the biological father.
All right, thank you.
Ms. Venzu, has anybody spoken to Mr. Stevens about paying for his own DNA testing?
We have not, Your Honor.
Does MDHHS plan to terminate parental rights in the future if he continues to not have contact with Felix?
I think yes, we would be left in a position where if he's not willing to make efforts to reunify, we would have to consider a goal change.
I have no further questions. Anybody else have any questions based on mine?
No, thank you, Judge.
No, thank you.
All right. Any further witnesses or evidence, Mr. Sommerfeld?
No, thank you, Judge.
Mr. Brown, witnesses or evidence?
Hey, Your Honor, I did not have an opportunity to speak with Mr. Stevens. His voicemail box is full. I did send a text message. I believe I heard Ms. Venzu state that he can text. So I don't know if he wants to speak or not. I would give you that opportunity, Mr. Stevens, if you would like to be sworn in, and I'll just ask you one quick question.
That's fine.
All right. Raise your right hand, Mr. Stevens. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, go ahead and put your hand down. Mr. Brown, go ahead.
Mr. Stevens, you've heard the testimony so far, correct?
Yeah.
And is the testimony as you've heard it accurate?
Yeah.
Thank you. I have no further questions, Your Honor.
Let's see. Mr. Delaney, questions of this witness?
Just a couple of follow-up questions, just for the record. And Mr. Stevens, I'm counsel for the children in this case. And for the record, you were never married to Courtney Self, is that correct?
That's correct.
Did you sign an affidavit of parentage? Do you know what that form is?
I think I did. I'm pretty sure. It was a very hectic time when he was born and a lot of stuff was going on.
The court asked a question of the prior witness about whether you might get an independent blood test to make a determination. Is that something that you're considering doing?
We were in the middle of it with my last lawyer, but then when we were getting ready to go forward with it, she, I guess, left her firm, and that left me without a lawyer.
Okay. And you can see the importance of the court's question. We want to know, we want to be sure, and so do you, that you're the father of the child.
Yeah.
Okay, and do you plan on following up with that? I certainly, as the guardian, don't want to leave that as an unresolved legal issue. What do you think you'll be following up on this?
I'd like to do the DNA test. I just wasn't sure how to go about it.
All right, I have no further questions. Thank you.
Ms. Hansel, questions for this witness?
No questions.
Mr. Sommerfeld, questions for this witness?
No, thank you, Judge.
All right, Mr. Stevens, I'm not going to ask you any questions. I'm just going to tell you what I'd like you and your counsel to do. I'd like you to meet with your counsel, whether over the phone or in person is up to you. But I need you to discuss moving forward, either with some sort of DNA testing or with your participation. And if you want to have the DNA testing done first, Mr. Brown can certainly contact MDHHS for avenues to assist in doing that. It may end up being that you have to pay for it, given the circumstances of the case with signing the affidavit of parentage, but they may be able to assist you with how that practically gets accomplished. The other side of it I need you to discuss is termination of parental rights. It may be not in your best interest to just simply wait and have a termination of parental rights done, because it may impact your relationship with other children in the future if you had that on your record. Mr. Brown can certainly discuss that further with you, but I'd like you to have that conversation with him so that next time we're in court, you have the ability to make a decision about where you want to go. Do you understand what I'm asking you to do, sir?
Yes, sir.
All right, thank you very much. Mr. Brown, any other witnesses or evidence that you have?
No, Your Honor, thank you.
I've kind of lost track. So Ms. Hansel, any witnesses or evidence that you have?
No, sir.
All right, have I asked everybody?
I'd like to call Ann Sullivan, if I could, briefly.
Certainly. Ms. Sullivan, you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you very much. Go ahead, Mr. Delaney.
Can you help us track down an affidavit of parentage? Do you know anything about it?
I personally have not seen the affidavit of parentage, but I do have a copy of the birth certificate, which I know that's not always the same, but he is listed as the father on the birth certificate. I did just look that up.
All right, and if you, at your convenience, if you could circulate that to counsel, and
Yes.
that would probably help Mr. Brown get started on anything that he's going to be doing. I don't have any further questions. I do have a guardian report when the court's ready.
Go ahead, Mr. Delaney.
The foster mother is here, Judge, and as indicated, she has all 4 children. Hopefully I'll pronounce all the names correctly. Legion is a boy, he's 12. Linka and Loki are twins, boy and girl, they're age 6. And then Felix, Mr. Stevens's purported child, that's a boy, he's 4. She's had these kids since March of 2025, so we're a year into this thing. She has 3 children of her own, which puts her on the short list for sainthood. I told her that, and when she got the kids, Felix was behind in speech and physically behind, and she's done a good job to get him back up to speed. The twins, the Linka and Loki, were held back in kindergarten for some educational reasons, and the children were almost all of them underweight when she got them, but she's really restored some of that. The recent parenting time has been a little concerning for her, and if it continues to be concerning, she's going to contact the department. It's supervised now, but she's going to contact the department to see what can be done to address that. So I don't mean to make that a looming threat for any of the parents, but you know, she wants to see a stable environment here. I know Ms. Venzu just had her hand up, so maybe she can add to that. But other than that, I mean, the kids had some trauma and there was some outbursts when she first got them, but she really seems to be moving well along with them. But just the note is we're a year in, and so the clock is going to be ticking on this. But I did want to thank for her exceptional efforts here. Thank you.
I would echo those sentiments. I do want to say thank you to foster mom for all the time, effort, and energy that you're putting into that. And I do see that the kids are doing well while they're in your care. So thank you very much. We do appreciate that. Any other evidence that anybody has, Ms. Venzu?
I just wanted to, excuse me, I just wanted to clarify, Your Honor, that the current parenting time order is that in-person is suspended and visits are only occurring supervised virtually, through virtual conferencing or phone. I would offer that it has been very inconsistent despite a schedule from Ms. Self. And so I believe that the inconsistency is the main barrier in having those be productive and healthy for the children.
Thank you very much for that clarification. All right. Mr. Sommerfeld, closing statements?
Yes, Judge, since this is date and time for disposition, I'd ask the court to adopt the recommendation. There were several parent agency treatment plans identified. However, Ms. Venzu stated the report period of October 7th, 2025 through December 30th of 2025 is the most recent and up to date, and that should be our guiding principle here as the starting point for this plan of reunification. Judge, I'm glad the court brought up an issue of, about a DNA, or this could lead to termination of parental rights. Another option, and again, this could be discussed with Mr. Brown, would be a voluntary release. It's not, it doesn't, although it's not a good thing, I don't think it has the same weight as an involuntary termination. So, but right now, this is reunification. If there is no engagement in services for whatever reason, ultimately the department, like Ms. Benzu said, we will have to switch over and start looking at the child's permanency as the guiding factor rather than returning the child back to the dad. Thank you.
Thank you. Mr. Brown?
Your Honor, no closing arguments. I would like Mr. Stevens, I don't know if he has a new phone number, but contact has been fairly difficult. So Mr. Stevens, you don't always need to wait for me to call. You can always reach out, leave a voicemail, do whatever you need to do, okay?
Okay.
All right. Ms. Hansel, anything as to this review? It's mostly on Dad, I understand, but.
I would have nothing to add on this. There hasn't been testimony about my client, and she hasn't testified, so no, I have nothing to
All
add.
right, thank you. Mr. Delaney, anything else to add?
Just briefly, obviously the child is 4, and that's a pivotal consideration, that the child either be reunified or that a different direction be looked at. Thank you.
All right. The court will adopt the recommendations that Felix remain in the care, custody, and supervision of MDHHS. And again, the court wishes to thank foster care provider for the good work that's being done there. We will also state that or order that Alan, Mr. Stevens, participate in and show benefit from his parent agency treatment plan, and that would be the one the current one from October through December of 2025. And then I'm going to make one additional order, simply that Mr. Stevens and his counsel, Mr. Brown, have contact and discuss DNA testing, termination of parental rights, and as Mr. Sommerfeld indicated, the potential for release as to the child. I'm not dictating that any specific action be taken, but I am going to require you to have a long conversation between counsel and Mr. Stevens about those issues, and then to contact MDHHS or the court with where you want to go and what you want to do. If it's simply to continue the normal course of action, that's fine. If he wishes to have DNA testing, that's fine. If he wishes to terminate his parental rights, either voluntarily or involuntarily, that's fine as well. I just simply want everybody to be advised what the plan of action is going forward, so we're not kind of left in limbo. And I'd like to have that accomplished within the next 30 days if we could do that. So Mr. Brown and Mr. Stevens, if you could plan accordingly, and then Mr. Brown, if you'd make the notifications thereafter, I'd appreciate that.
Yes, sure.
All right. As to the review hearing, that is all on that. We will now move to the pretrial on mom. Ms. Hansel, how is it that you would like to move forward with this case at this time?
Your Honor, we do have a plea I think we have agreed to. I would like to talk to my client and to the prosecutor, maybe in a breakout room. I don't know if that's appropriate right at this time, due to the court's docket, but I believe we have something that we can agree on. So I'd like to, I have not been able to personally contact my client, but she's here today. So I would like to at least set up an opportunity to talk with her and with the prosecutor. I believe we have an agreement.
All right, my next case is not till 2:30. All right, I do believe we have a little bit of time right now at the moment, so let's strike while the iron is hot.
Okay.
My next case is not until 2:30, so I can give you about 15 minutes, and then we'd have 15 minutes to take care of whatever else we would need to do in this case before the next one starts. Just you and your client in the breakout room, is that what you're asking for, Ms. Hansel?
I would ask for Mr. The prosecutor.
Mr. Sommerfeld?
Yes.
All right, so we'll put Mr. Sommerfeld, Ms. Hansel, and Ms. Self in a breakout room so where they can talk privately. The court will then simply go off the record until everybody's back, so everybody can take a little bit of a break. We'll give you approximately 10 or 15 minutes to accomplish that, and then we'll be back on the record. So court will be in recess. We'll put the appropriate parties in the breakout room, and everybody else can take a break for about 10, 15 minutes. Thank you. Ms. Hansel, Mr. Sommerfeld, and Ms. Self are back from their breakout room. Do we have a resolution of this matter, Ms. Hansel?
We do, Your Honor.
And what is that resolution?
We have verbiage for a plea, which the prosecutor accept. We believe it covers everything. My client is willing to accept responsibility for it, and we're seeking now the next steps in which she will work with the agency on regaining custody of her children.
Judge, Ms. Hansel has 3 items that she will ask her client. Ms. Hansel will then put that in writing, send it to me, and then I will forward it to Mr. Delaney and the court. We would ask that be attached and incorporated by reference, much like we do with mediation agreements. But for purposes of today and historically, not having everybody here to actually do something, we would like to accomplish the plea today through that process, even though we don't have it written down and the court's looking at it. Ms. Hansel has gone over that with Ms. Self, and she has agreed to that language. And Ms. Hansel will question Ms. Self regarding that. She will make admissions, and that would be after the court advises Ms. Self of her rights under MCR 3.971.
All right, Ms. Self, you have heard what the lawyers have said. Is that what you want to do?
Yes, Your Honor.
Let me tell you what your rights are so that you can make an informed decision. Right now, if you wish to enter into this agreement, you'd be giving up your right to have a trial and all of the rights that would go along with a trial. Those would include the right to have your attorney represent you at a trial, the right to have a trial by a judge or by a jury, the right to have the petitioner prove the allegations by a preponderance of the evidence, the right to have witnesses appear and testify, and to cross-examine witnesses, and to get an order from the court called a subpoena to require your own witnesses to testify. In addition to that, you could testify or you could not at your choice. In addition to that, there would be some consequences of your plea as well that I want you to understand. If you enter a plea, that would be a matter of court record, and that could be used against you again at subsequent or later court hearings, up to and including a termination of parental rights hearing, if that were ever to be a possibility. If your parental rights are subsequently terminated, and I'm not saying that they are going to be, but I'm required to advise you of that. You'd also continue to have your obligation to provide child support until that is ended by court order. Do you understand all of those things?
Yes, Your Honor.
Judge, could we
All right.
place Ms. Self under oath and also the department, and I would ask the court, as far as reading the petition, the department would waive that, but I'd ask that all parties be asked that question.
Thank you. Ms. Self, if you raise your right hand, please. Swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, thank you very much. I've just gone through giving you your trial rights and your plea rights. Do you understand all of those rights that I've just recently given to you?
Yes, Your Honor.
Do you have any questions about any of those rights?
No, Your Honor.
Do you need any additional time to speak with them speak with your attorney about those rights?
No, Your Honor.
All right, and the last right that you have is what are called your appellate rights. Appellate review is available to challenge any errors in this process called the adjudication, that is the taking of the plea. You have the right to the appointment of an attorney and to the preparation of transcripts. And if you go through this process and don't timely appeal, you would lose the ability to contest the court taking jurisdiction. That is, you'd be giving up your right to say that the court didn't properly take power or control over the case. Do you understand that?
Yes, Your Honor.
Knowing all of that, is it still your desire to enter a plea as the attorneys have talked about for today's purposes?
Yes, sir.
All right. The attorney for the Department of Health and Human Services has said that he does not wish to have the petition read to you. Do you wish me to read the petition to you, or are you satisfied that you understand what's in the petition?
I understand what's in the petition. Thank you, sir.
All right, Ms. Hansel, do you approve of your client's waiving of the reading of the petition?
I do.
All right. At this point, it appears that we need to have the factual basis established. Ms. Hansel, do you have some questions for that purpose?
I do. Yes, sir.
Go ahead now, please.
Okay, and so Courtney, do you admit then that you intentionally misled the CPS workers regarding the cause of the injury to your minor child Felix's face, which happened as a result of you throwing a phone?
Yes, ma'am. I admit.
Okay, and do you further admit that there's been a lack of progress in maintaining your housing, employment, mental health care for Felix, and transportation?
I admit.
Okay. And lastly, do you admit there was a conviction of fourth degree child abuse in Otsego County against you on July 31st, 2025 involving these children? Okay, that's all we have, Your Honor.
All right, Mr. Sommerfeld, do you believe that there's a proper factual basis for the court to take jurisdiction in this matter?
Yes, Judge, I believe both parts of the statute, 2B1 and 2B2, would be met by this. I don't know if it was my connection. Mom's last statement regarding question 3, did the court hear an affirmative? Mine was a little garbled.
I saw her nod and it appeared to be to me, but I'll ask Ms. Self, you are in fact admitting that there was a child abuse in the fourth degree conviction July 31st of 25 involving the same child. Is that correct?
Yes, Your Honor, I do admit.
All right, thank you very much. I appreciate that. All right, the court will in fact accept the plea, does find that it was knowingly, intelligently, and voluntarily given. It does appear to meet the requirements of MCL 712A.2B involving the two paragraphs in the petition as outlined, and therefore the court will accept that. We will then refer the matter for dispositional hearing in the future in the preparation of the appropriate reports by MDHHS. Ms. Self, I'm going to ask that you continue to participate in that process with MDHHS as they prepare the dispositional reports, the parent agency treatment plan, case service plan, those sorts of documents. Ms. Hansel, is there anything else that we can do today?
I don't believe so, sir.
Mr. Sommerfeld?
Just that I would ask Ms. Hansel to forward the factual basis so that all attorneys could see it in writing, and then we will forward it to the court. And if we could all agree that that would be attached and made part of the record today for respondent Ms. Self's plea today.
I will do so. Thank you.
Thank you very much. The court will look forward to receiving that. All right, that's all for today then. Thank you very much. Appreciate your assistance. The court will be in recess on this case.
Share your thoughts in the comments, and don't forget to subscribe for more courtroom breakdowns.